Good morning to everybody that's attending, our large crowd here. We are here today working as a subcommittee on two bills, HB 112, 112, and HB 510. What we are going to do is we're going to go into a caucus immediately and discuss these things as individual caucuses and then come back. I hope to be able to get through these bills fairly rapidly today, seeing that there is also another group, advisory commission that two of us are on, which starts over at DOE at 11 o'clock. So there should be time to do this. So at this time, we will break into caucus. I will distribute now to folks in the crowd some amending language for 510. And that's the bill dealing with establishing certain due process rights for students, student organizations, faculty members facing disciplinary actions by state institutions of higher learning. So with that, we're going into caucus. We will be caucusing across the hallway in the small room to the right.
All right, we'll go to the left.
Go left.
There's a phone booth down here. Honestly, we could call.
Okay,
Mr. Chairman,
yeah.
can we get 5 minutes?
Well, what we'll do is we'll do the first one first,
Oh, okay.
and then we'll take option for a
12 after
caucus.
that?
There'll be a caucus for
Okay,
that. Yeah,
thank you.
yeah, you're welcome. Okay, we're going to go ahead and open up the session today for the subcommittee dealing with HB 510 and HB 112. We are going to first take up HB 510. And what we have before us is we have an official amendment. We have one with some amending changes to the bill as it's been introduced. And the changes I'd like to go over with you right now. Does everybody have a copy of the changes? There's 4 pages. The first page, page 1 of 510, we have already approved as a subcommittee the changes to the definitions for public institution of higher education, which is on page 1. And then on page 2, we changed the definition for student. It's on line 3. And we changed the definition for student organization. And then down on line 12, due process rights established in all disciplinary proceedings as defined by RSA 188K:2(1). Those were in that amendment which we approved the other day as a subcommittee. And that was done unanimously by the group here. Going on down on page 2, underneath the due process rights established, which is up on line 11, on line 23, there is a change here, and it reads, recipients must take reasonable steps to prevent the parties from disclosing to third parties information and evidence obtained through the grievance procedures. There was a communication which I received from the New Hampshire Coalition Against Domestic and Sexual Violence. And there was a sentence very similar to this within that, which said this. I've added to it to third parties, information and evidence. So that's the change here. I'll go through all these changes, then we can discuss this. On page 3, there was much concern that, on the bottom page 2 and going to the top of page 3, it reads, the right against self-incrimination, provided, however, that invocation of this right may afford a basis for the decision maker to draw an adverse inference against the person who does so. In communication, which we've had with through the Department of Education with a firm which is contracted by the department oftentimes to give advice or comment on issues which are relative to Title IX, it's been advised to scratch out everything after the right against self-incrimination, period. Okay, so then going on to the rest of it on page 3, the right to confront and cross-examine witnesses who provide evidence against the student organization, or faculty member. And then it goes in, provided, however, that if a person who claims to be a victim of the conduct giving rise to the disciplinary action objects to being cross-examined by a person accused of the violation, the hearing officer or panel may require that the cross-examination be conducted by another person selected by the accused and approved by the hearing officer or panel. The person accused shall have the right to be present when his or her accuser is cross-examined. We had a lot of discussion on this in previous times, saying that we don't want the person being cross-examined by a person that's, I don't have the legal terminology of it, but we want to make sure that it's done by a third party. Going on down to the bottom on page 3, there's also a change right there under this section that starts off the procedural rights, including the hearing specified in paragraph 1, shall be afforded to a student organization, or faculty member prior to the imposition of any discipline, provided, however, that in cases where the public institution of higher education can show a substantial likelihood of an imminent threat of physical injury to any person or significant damage to property. That part right there has been changed, and the issue of property has been removed. This is also a recommendation that came in from the organization that we have worked with as a state, Department of Education, with the outfit down in Boston, Brody, Harding, Perkins, and Keston. So it would read now, likelihood of, and the slip you had there leaves out the word an, it needs to be put in, an immediate threat to the physical health or safety of any student or other individual before a hearing can be held. So it takes out property. Those are the changes which we have on this right now, so I will open it up to discussion. Is there any discussion on what we got for amending changes? Yes, yes. Representative.
So I, I still think that this is a needless bill. I still think it's a solution looking for a problem. But even with the amending language, first of all, if we could go to page 3, the top of page 3, line 5, lines 4 and 5. I took great offense, and maybe it's just me, that if a person who claims to be a victim of the conduct claims to be a victim, so already it sounds like nobody's believing the victim. It just, that language like made me twitch. Anyway, I see this as still the last line there, lines 9 and 10, the person accused shall have the right to be present when his or her accuser is cross-examined. Again, that just screams intimidation to me. I don't see having the person accused sitting there while the accuser is being cross-examined. If my daughter was raped, I wouldn't want her accuser to be sitting in front of her while she was having to talk about what happened. Again, I don't see any way that I can support this bill, even with the amendments. Although I do thank you for the beginning parts, the first parts of the amendment. I just think that the whole bill is needless.
Yes, Representative Popovich.
Thank you, Mr. Chair. I appreciate my colleague's concern, and very bluntly, I don't think that we were expecting that this amendment will change the overall position on the bill. I understand that. I just want to state two things. One, that we made every effort to address every reasonable concern we heard about it. And if you do read the language of the amendment, you should be able to see that when concerns were raised, we tried to find the best way possible to address them while preserving the intent of the bill. The other thing on the language is that at the end of the day, before any such matter is decided, all we have are claims. I mean, somebody claims something bad happened, somebody claims they didn't do it. The whole point of the language is to recognize that at this stage, those are accusations and defenses, and nothing has been established to the facts yet. The point of the proceeding is to allow for those facts to be established, and then we have somebody who is guilty or not. So I understand that, people may be troubled by the language, but I cannot find another way to preserve due process, without recognizing the fact that until those proceedings are complete, all we have are accusations and defenses, but no clear verdict yet, so.
Further discussion from, yes, Representative Burton.
Can I ask the representative a question and then speak? Just a quick question. No one's answered the question yet of why this bill is needed. It's because the process at all of these schools is working extremely well.
Representative Popovich?
With all due respect to my colleague, I believe that the question has been answered a lot of times. I do believe that the colleague who I respect a lot just doesn't feel those reasons may be valid. We clearly express that the current process does not respect due process and that these changes are needed. Anytime when we keep saying that the current process works just fine, we are basically begging the question of, if all that we ask for in the bill is already there, then clearly there is no impact on the university. And if there is an impact on the university, it is because those basic things that are here are not currently implemented. Either way, the need for the bill is clear. We do need to protect the rights to due process of everybody involved. Those are very serious accusations. Yes, they are not criminal in nature. Not at this time, but they can have huge impacts on the lives of those people, so they should have the right to defend themselves against very serious accusations that could lead to their suspension or expulsion.
Thank you.
No worries.
They have sufficient processes already in place at each institution. We met with the Student Senate at UNH last week. 10 state representatives and the full Senate. There were 30 students there. And we talked about a lot of issues, like a representative that says he liked cutting the university's budget. A woman who was losing her major wasn't very happy to hear that. There was other questions about the cost of education. I asked how many are going to live in New Hampshire when you finish, and it was about half. But the rest were concerned. They were going to have to leave the state. But then I asked, what about due process? Is there any problems with due process? Oh, no, I don't know any. They looked at each other. No, we've never had a problem. We have all these processes in place now that if someone has a problem or an incident, they can go through the process. It protects the students, and the perpetrator will be punished. If you read the piece that we got from Shannon Reed, you'll also note that this bill, if passed, would disrupt and upend collective bargaining agreements at the school. There are existing laws, federal laws and regulations that are also been negotiated. This would upend those. Has anyone looked into how disruptive this bill would be with any of those? And you get back to it, for what cost? They already have. I mean, I was the assistant dean there. I used to do this. They've got plenty. And you know why they have them, Representative? We in education believe that we should behave the way we'd like our students to behave once they get out in the world. So we tend to overdo things like due process and honesty and fairness because we know when they get out in the world that they should have those values. So often, in my experiences, both as a college president and as a dean, we always tried to make sure they were the best processes possible so that the students would know what they look like when they see them. What this bill seems to ignore the fact that the universities and the colleges have policies and procedures in place. Now, I do note that the amendment still doesn't guarantee that the victim of an assault will be re-victimized because it says they may, I think the language is, the panel may require that the cross-examination be conducted by another person. It doesn't say it will be.
And then
Then they have the right, the person accused will have the right to be present when his or her or accuser is cross-examined. That is absolutely intimidating. When my daughter was in college, she witnessed an assault. It was not at a public university. And I was kind of shocked by the way they didn't have processes in place like UNH does. And I spoke to the president about it. And they were going to do a session like that. My daughter did not want to go out in public because she'd be ostracized by her friends. I just don't know why you want to do this when they already have sufficient processes and procedures. And the sponsor hasn't given us any either. Can you give us a case where?
Well, if you want to talk to, you have to talk through the chair to talk to the sponsor.
I asked him, and I'm not questioning the sponsor's values or anything else. Believe me, I have great respect for him. But I'm still wondering what incident sparked this. Is there something there that we haven't heard about that is so egregious that you would undermine all of the university's procedures and cause them to have to pay money to rechange everything, go back and renegotiate collective bargaining agreements for a problem that I don't see existing at this time? And thank you.
Okay, I think you're asking some questions, and we do have the prime sponsor here. So perhaps Representative Lynn would care to respond?
So thank you very much. And thank you for the question. I guess as I said to you, I think the last time that I was here, if you're asking me, to give you some specific case in New Hampshire where, where some student was treated, absolutely unfairly or something. No, I cannot give you that off the top of my head. I am aware that these kind of things have happened at other places around the country. But the thing that I have a real problem with the objections that I've heard is this. When you say that this bill will upset the current procedure that is working just fine, as you say, I think the question that comes to my mind is, I think that in some sense that's kind of a red herring, because the question that I have is, what are the procedures in this bill? What are the rights that are granted to a student or a faculty member or whatever in this bill that you think are unfair? And if you don't say, and I haven't heard anybody say that, well, this right is unfair, this right is unfair, this right is unfair, with one caveat that I'll get to in a minute. I haven't heard anybody say, oh, don't give them that right, that's unfair to give them that right, or don't give them this right. And so you don't have any objection, with the one caveat that I'll get to in a minute, to the rights that are granted in here, but you say, well, the system that is working, that we have now is working fine. So it seems to me that has to mean one of two things. Either the system as it currently exists has all these rights, and if that's true, then my response is, so what's the problem? We're going to pass this bill and it's not going to make any changes at all because they already have all these rights. But I suspect that the reality is that the procedures that they have now do not afford all of these rights. And so if you're not saying that some right in here is improper, that it shouldn't be granted, then my answer is we should be giving the people the rights that everybody agrees is a right that students or faculty members that are accused of something should have. And then the one point that I think you raised, Representative Brioche, Bricky, Representative Bricky. The one thing that you raised is the issue of, well, I guess in some sense, both of you raised, the issue of being able to cross-examine victim and having the accuser be able to be present. And I guess I have to say, I think that this kind of goes to what part of what you were saying before. You seem to object to reference to the person being referred to as the claimed victim. But in fact, I mean, that's the problem I have with your position. Because somebody comes in and says, I was raped, for example, or I was, sexually assaulted in some way. Our whole system says if you make a claim like that, that doesn't mean that, that's the end of the matter. I've claimed I've been abused, and that's the end of the matter. I have been abused. We all must accept what I say. No, that is not, that is the whole purpose of our system of due process is, wait a minute, you claim that, now we have to decide whether that's true or not. And the person that you've accused, who is facing, some pretty significant, this isn't a criminal matter, but still, as Representative Popovici-Muller pointed out, still this could affect someone's life forever. That person has a right to a defense. And so we can't go under our system on the presumption that if I say I've been victimized, that's the end of the matter. I just have to be believed. That's not the way our system works. And so, when you say that you have an objection to the person being present when they're being accused, boy, that again is a fun. It seems to me that if I'm saying you did something wrong, I ought to be able to sit there and look you in the eye and say you did something wrong. Because if I can't do that, then that's the whole underpinning of our system. You have the right to have me look you in the eye and say you did something wrong to me. And to say, well, I might be intimidated by it. Well, I'm sorry, but that's kind of the way our system works. In fairness to you, if you're the accused, in fairness to you, you have the right to look me in the eye when I'm saying that you did something wrong to me, and you have the right, and I'm perfectly willing to have the situation where you may not personally cross-examine me. You have to have somebody else if that's what if there's a concern that you might be so emotionally involved that you would act improperly and cross-examine me or something. Fine, let's have somebody else do it. But I think that's just it's really sort of basic fairness. We don't want to have a system like they have in China or the Soviet Union or whatever, where you can, if you're sort of the right, if you have the right background or the right friends, then your word goes without saying. But if you're not, then you're in trouble. That's what the whole idea of due process is about. So that's my response. Thank you. And I apologize for going on so long.
Representative Lynn, I do have another question that Representative Bricky was addressing there. When we're talking about this cross-examination by another person, and I'd like to know from your perspective, because this is certainly well out of my wheelhouse as far as experience, and I haven't done it, where a hearing officer or a panel makes the decision that another person should do the cross-examination. Where we have in law right now, or in this proposal, where the word may is used, instead the hearing officer or panel shall allow. Now, and that was a question was brought up by Representative Bricky right at the beginning. How would you, or a hearing type officer that's given this authority to make this choice, should it be shall or should it be may? And if it's may, why may?
I guess Sorry, I think that it should be May for this reason. It seems to me that the hearing officer ought to have the discretion, because I can think of two situations. You know, suppose you have the situation of, let's take what you know in reality might be the one that would particularly prompt this. Suppose that there's a young woman who claims that she was raped or sexually assaulted by another student, and that the other student is a male. I can sort of envision two situations. One, you could have a situation where the accused, it is giving off a number of signals just through the course of the hearing, so that the hearing officer knows, the person I'm dealing with here as the accused is a loose cannon, and if I let this person cross-examine the victim, it's going to end up in a shouting match, and he's going to be really, trying to intimidate her, and the questions are not going to be particularly relevant. It's going to turn into a horror show. There, I could easily see that. I would assume that the hearing officer is going to say, no. If you want to cross-examine the alleged victim, I'm appointing somebody else to do that. But I don't think that always will be the case. I could think of it would seem to me you could have situations in which the hearing officer might say, this person that is accused has, the way he's behaved himself throughout this proceeding, he hasn't been, been particularly aggressive or been, excuse my language, but he hasn't been an asshole during this proceeding. He seems to be behaving himself. I'm willing to allow him to do the cross-examination. Understand that the hearing officer always, if the hearing officer starts to let the person do the cross-examination, and it turns out the hearing officer was wrong, the person does get up and starts to get really aggressive or insulting or that kind of thing. Sure, the hearing officer can stop it right then and say, wait a minute, I've changed my mind. I'm not going to let you continue with this. If you want to cross-examine, I'm going to, we're going to have somebody else do it. So I think most reasonable hearing officers would want to have that discretion, and I think they should have that discretion.
In Title IX, I think it talks about intimidation, and I'd have to go check to be sure of that. But how can we avoid that intimidation by allowing an individual even to start a cross-examination? Should we not be proactive and say it shall be done by another person?
Well, I guess, what I would say to that is this whole issue of intimidation. I mean, I would agree in some sense that if you're accused and you're facing your accuser, that sure, in some sense, that's intimidating. I agree there is some inherent intimidation in that process. I agree with it. But, I guess what I say to that is it's like in some sense, that's like, give it like the whole idea of trigger warning. There are some things in life that are just kind of inherently intimidating. If you're accusing somebody of having raped you and the person is there and the person is saying, I didn't rape you, this was consensual or whatever the defense, or I wasn't there, it was not me. I mean, is that going to be, is there some inherent level of intimidation? I suppose you could say that, but again, our system says that we want to protect the rights of somebody not to end up being falsely convicted or falsely found responsible for something they didn't do. And so I think I guess I would say that to the extent that there's an inherent intimidation in having to face your accuser, that if, you know, that in itself that's just the way our system operates. If it's something more than that, if the person, you know, is not going to be able to conduct themselves properly in conducting the cross-examination, that fine. Then it makes perfect sense to require that somebody else do it. But I don't think that that's always the case.
Okay. Thank you. Representative Popovich.
Just a quick follow-up. I hear what you're saying, and I greatly respect your position, but would you feel that using the word, you know, in the hearing officer or panel shall require, is that a material change to the law? Because it looks to me like we're trying to extend deference to that, you know, hearing officer or whatnot, but at the end of the day, we should be able to say, look, if the accuser requires a third party to do it, just do it that way. Would it really harm the bill in any meaningful way if we just put shall
Yeah,
there?
no, I mean, I hear what you're saying. I guess I would prefer may, but I have to agree. You could say shall, and that would mean that it's in the hands of the accuser. If the accuser makes the request, the hearing officer has to do it. I mean, I guess I would say I could live with that. I think it's not to me, it wouldn't be the preferred way, but I could, you know, fine. I could live with that if that's what you wanted to do.
Further discussion.
I really have to disagree with you. If the captain of the football team sexually assaults a young woman, is that an equal relationship when they get out into a public hearing and the star of the football team humiliates a vulnerable woman? You think that is an equal thing? And by the way, I'm sort of confused by, and I don't know if you want to talk about your career as a judge, but you look for precedent, I would assume, when you tried a case, but you're not looking for you haven't looked at all the other ways that public education handles cases.
I don't think we want to go down that road right now. I think the question you're asking, and you've heard just Representative Popovich address this issue of possible intimidation and changing the may to shall possibly. I heard the response from the prime sponsor of the bill saying, yeah, it's okay, go with it. So I think that, you know, if we change that may to a shall, I think we eliminate that aspect totally. And if that individual comes to the hearing officer or the panel and says, I don't want to be cross-examined by this person, I want another person, then it shall happen. I think that is, I don't know if that, you know, I think that's where we need to go, and I don't think we need to discuss this one much further.
One more thing. As the president of a college, the number of students came to me and reported issues. And when I said, we have a procedure, it's just like this one. And they said, but I can't do that because then I have to go back into the student body and my friends will disown me because I reported this, even though it's true. And I'm concerned about that. And your dad, you're sending your kids off to college. I would think you'd want your kid to be protected all the time. And anyway, I don't think it's worth going much further, Mr. Chairman.
Well, I guess I would say, when I having put 4 kids through college, I absolutely want them to be protected. But the problem is, I would want them to be protected to equally if they were the ones that were accused of having done something wrong. And I think that's, our whole system develops these due process rights because we've made the decision as a society that we want to balance out the rights of the accuser and the accused, and this is the kind of way that our system has decided it. And I guess the only other thing I would say is except for this one thing on the accuser, on the cross-examination, which, I agree is a substantive thing, and seems like you've kind of come to a sense of where you want to go on that. But other than that, I keep coming back to my point that you say that everything is fine under the current system. But what of the rights that are specified in this bill do you think shouldn't be part of the current system? Because if you don't have an answer to that, then there's no reason not to put them in the current system.
The question is, what rights do you think aren't in the current system? And you haven't looked.
Representative Popovich, do you have a?
Yes, Mr. Chair, I'd like to make a motion that this subcommittee recommends the adoption of the language that we have in front of us with the following minor changes that are to be reviewed by the OLS by the time we meet on Thursday in the full committee. On line 24 of page 2, where it says prevent the parties from disclosing, we need to add disclosing to third parties and then continue with information and evidence. On page 3, line 7, we will replace hearing officer or panel may require with hearing officer or panel shall require. And then, nope, and those are the only changes that I see to the printed
On line
language.
29.
Oh, line 29, oh yeah, in the line 29, we have an "and" that is struck out, that shouldn't be struck out, that's just a missing, it's a minor error. So I would like to make the motion that we recommend.
I'll second that motion.
Thank you. And if I may briefly speak?
Yes.
All I want to say that hasn't been yet said today, and God knows I don't want to repeat stuff that was already said, we've already gone for a bit. I'm surprised that anybody would object to the fact that this bill will actually respect the collective bargaining agreements, and then when they expire, it will give additional protection to the union members. I do not see how giving union members more rights to protect themselves against accusations is something that can be found as objectionable. That's all I'm going to say again, because I didn't say that before, but everything else has been said. Personally, I'm kind of ready to vote.
And that's the second. I have no further discussion. Further discussion from the committee, subcommittee? Not seeing any. Madam Clerk, would you please call the roll?
Representative Burton,
No.
Representative Bricky,
Absolutely not.
Representative Popovich,
Yes.
Representative Ladd,
Yes.
and Representative Brown, yes.
Okay, the motion passes, and we will get an amendment made of reflecting these changes we have on this draft right here with those components which were mentioned by Representative Popovich. So this closes the action on 1 of 510. We will take now a short caucus for everybody to review 510, the sheet which was handed out, and we'll come back and
112?
excuse me, yeah, 112, yeah. And we will come back to take action on that one. Thank you. Okay, we're going to open up the discussion here today for HB 112. This is bill requiring students in the university and community college systems of New Hampshire to pass the United States Citizenship and Immigration Services civics naturalization test. So I'd like to, at this point in time, to recognize Representative Brown for a motion, please.
Yes, I'd like to move to pass for HB 112, and I believe there are some amendments to this particular bill.
Okay, are you suggesting to make a motion to move forward this draft that which we have in front of us?
Yes, the
You have it?
amended draft, yes.
Okay. Is there a second to that? Representative Popovich seconds that motion. Would you please then discuss your motion, Representative Brown?
Yes, the revised amended version addresses many of the questions that have been raised about a citizenship civics exam for college graduates in New Hampshire. Several points were made in the revised draft, including on page 1, line 16, that every undergraduate student, rather than every student admitted or transferring, shall, as a requirement for graduation, in addition to other requirements, perform the following: A, show proof of having passed a version of the U.S. Citizenship and Immigration Services naturalization test with a score of 70 or better. And in the amended draft, we've added, or B, take a civics course that covers fundamental American documents as part of the general education curriculum, or pass said civics course competency test. So instead of simply passing an immigration services exam, civics exam, there is also the option of taking an undergraduate civics course on American institutions.
Do you have any changing on line 25 there?
On page 1, on line 25, where it indicates take a civics course, being a college professor myself, I ask that we amend that to say successfully completes a civics course.
Okay.
Mr. Chair. Could we pass that change also on page 2, line 16?
And on the next
Well, have
page.
you discussed what's on the bottom of page 31?
No, I have not.
We haven't gotten
On the
there yet.
bottom of page 1, line 31, there was discussion of military service as a qualification for demonstrating civic engagement at past meetings. So there's been an amendment here at the bottom, line 31, that states exchange students, foreign nationals, military personnel on full-time active duty, and then on the next page 2, line 1, or part-time service, or a veteran pursuant to either RSA 110D3 Rome 2 or RSA 110D3 Roman 20 shall be exempt from this section. So that covers the issue of if you're military personnel or you've served in the military, isn't this simply redundant if someone has done this service? That certainly demonstrates civic engagement. Another change on line 8 of page 2 was to change the date to July 1, 2027. Shall be the start date for the requirement. And this section, starting on line 6, indicates again that every student admitted to the institution shall show proof of having passed a version of the U.S. Citizenship and Immigration Services naturalization test, and again, the section that was added successfully completes a civics course that covers fundamental American documents as part of the general education curriculum, or pass said civics course competency test. So there is that option of completing a course or completing a competency test tied to the course. And then again, at the bottom of page 2, there's been a change that exempts exchange students, foreign nationals, and we've added military personnel or full-time active duty or part-time service, or a veteran pursuant to either RSAs as listed above.
The effective date.
And the page on line 25, the effective date has been changed from January 1, 2026 to July 1, 2027.
Any further discussion on this? Yes, Representative Bricky.
Is there a new fiscal note?
No.
More?
Yes, go ahead.
I imagine that this is going to add even more to the original fiscal note, which was at $1 million for the undergraduate system in the community college system of New Hampshire. So I do not see how I can put this requirement onto the university system and the community college system if it's going to cost them more money, and we are just taking money away from them. And we did take money away from them in this budget. So for that reason, I commend you for trying to amend it. And but for that reason, I will not be supporting this. Thank you.
You're welcome. Representative Popovich?
Thank you, Mr. Chair. Obviously, it's not possible to get a, fiscal note in the timeline that we are working on. But I would like to say two things really quickly, is that it is my understanding that all this does is that it gives the university more options. So it cannot possibly increase the total cost because the university can be free to just choose one course. And we already know that's, it has a fiscal note, which for the record is higher than it should be in my professional opinion. But basically, this would not increase the overall cost because the university can choose whichever is the most cost-effective way of complying. Therefore, if anything, I would see a positive financial impact from this language compared to the original bill language. Thank you.
Further discussion, Representative Burton?
A couple of questions. What if there's not a civics course at the institution that covers fundamental American documents? Would the institution have to put one up?
That's what you just said. No,
No.
the choice.
Okay. The other question I had is if military personnel on full-time active duty are assumed to have the equivalent of the knowledge that the test would show, what about in a community college? You get former government employees, you get former diplomatic service people taking courses, you get all kinds of people seeking degrees that the average age is 27. That's just singling out military people and assuming that it's the equivalent of a civics course or the exam. I don't know. Of course, it wouldn't apply to that many students at UNH because in-state students have to pass the course anyway. Again, when I asked the students at UNH, they looked at me like I was crazy. What do you mean? Take a test for civics? We already got that. Anyway, thank you. That's it.
Yes, Representative Popovich?
Very briefly, I appreciate my colleague's concern, and I agree that there may be other people who may not have already passed the long USCIS test and do not qualify through exemptions as described at the bottom of page 1 here. But the civics course requirement gives the opportunity to pass said civics course competency test. So people can test out of this requirement. They wouldn't have to pay tuition or spend time studying what they already know, just as long as they prove they already have a mastery of the topic. This is the standard procedure with any other academic course, so I think this is perfectly addressing everybody's needs there.
I might add that there are a number of states that are currently requiring their students, undergraduate students, to take a civics course covering the fundamental documents that are part of our country here. And I'll just read those states off to you. Arizona, Arkansas, Florida, Georgia, Missouri, Nevada, North Carolina, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah, and Wyoming. So this is something that I can recall even years ago when I was here going to the University of Maine, which was part of the old Yankee Conference. I was required to take courses in American history and government. So I feel that this is an option where you don't have to use the United States Citizenship Immigration Services test or assessment. You may have the option of taking a course as part of your Gen Ed curriculum, or if you feel competent enough and you can take the competency test for that civics course. If you pass that, just like we do in the high schools, you don't have to take the course. So I think this provides that option. In terms of what the costs are, I don't believe the costs are going to be as high. I've tried to do a little bit of work in terms of some of the costs which are projected in the fiscal note. I do know that the Department of Education spent $500,000 initially in implementing that test, but had to go back to GNC and ask for another $800,000 for the next 5 years to do this. There will be some expense. This is one of the reasons why we see this, the effective date of this being put off until 2027. Further discussion? Not seeing any. Madam Clerk, would you please call the roll?
To pass as amended. Representative Burton,
No.
Representative Ricky,
No,
Representative Popovich,
Yes.
Representative Ladd,
Yes.
and Rep. Brown, yes. Motion passes.
Okay, so we will get copies made of the two bills which we took today, taking those copies which we had, amending those copies with the terminology which was expressed in both meetings, and have that available for the meeting on Thursday next when we are taking up all our retained bills. I'm not seeing any more discussion. I know we have a meeting elsewhere in about 13, yes?
we have, so I just want to make sure, in the House record, it says on Wednesday, November 12th, Public Higher Education Study Committee is supposed to meet at 1. We are not meeting at 1, correct?
No.
On Wednesday.
The higher education?
We're meeting.
We are higher education, aren't we?
No.
That's
Higher
higher
education is
study.
the oversight committee that's chaired
Gotcha.
by Senator Ward.
Gotcha.
Yeah.
Forget I said anything. Thanks.
Yeah, it's complicated. There's a lot going on. And then we meet on the next day on the Thursday. Yes. With that, we are concluding today's subcommittee. Thank you very much.